I work this thing. God, resize it to change the video size on the number of videos. Got it. I don't even know what that means. Calling users can unmute by using.
Happy Wednesday, everyone. Um,
Yep.
Mr. Gallagher, looks like we have everyone here.
Are we ready to go?
We can start with the preamble.
Okay, sounds good. In compliance with notification requirements of Ohio's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting has the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. By Let's see. Call-in users can unmute by using *6. All meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. All requests to speak on a particular matter by way of our website and email have been considered. We have also received emails from those who have provided written comment on a particular matter. Okay, Carmel, you want to call the roll?
Mr. Maschke,
Here.
Mr. Bradley,
Here.
Mr. Dink,
Here. Mr.
Gallagher.
Here.
We have a quorum.
Okay, so we'll call the, well, is Miss Aston available?
I am. Thank you, Mr. Chairman. Patricia McGinty Aston for the City of Cleveland. If we could verify the live stream, please.
Maurice Rollins, City Planning. Yes, we are live streaming.
Thank you, Maurice. And as we do each time, Mr. Chairman, the city does object to the use of the chat based upon the Supreme Court guidances that were published at the beginning of pandemic. And as the basis, we would state that if we were in room 514, there would not be a chat going on separately. Thank you, sir.
Okay, thank you. Okay, we'll call the first case is docket A 141-21-923 East 72nd Street.
Application and fees are in order. Notice of violation into condemnation of the main structure issued on November 3rd of 2021. Appeal statement received November 30th of 2021 requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law, with the appellant or his or her attorney or representative. Please state your name for the record. Did anybody say anything? Can you guys hear me?
This is Patty. I hear you. There's a Marquez Grays on here that looked like just unmuted, but I'm not hearing that person, but I see them in the panel.
I heard him, but it was very low.
Okay, Mr. Graves,
Yes. All right. Good morning.
we need you to speak up a little bit, and I'm going to swear you in, okay?
Okay. Thank you.
Okay, so solemnly swear to tell the truth, the whole truth, so help you God.
Yes.
Okay, go ahead and proceed and let us know what your plans are.
Well, currently I'm on East 9th and St. Clair, headed down to Building and Housing to file the contractor registration and also to submit my plans and to pull permits. And I first want to apologize for not having it done prior to this call. I had my insurance agent did not sign the bottom of the bond, so I had to run out there this morning, and they opened at 9. So I'm just a little bit behind with the submission for today, but I do have drawings to do the proper renovations to this building.
Mr.
Okay.
Chairman, we do have Ms. Davis with her hand raised.
Okay, Ms. Davis.
You're muted.
I'm sorry. Mr. Chairman, just to let everyone know, I did receive an email from Councilman Harrison about 9:30 this morning. I don't know if you want me to read into record his testimony now or wait till after the Department of Building and Housing.
I guess we'll wait till after Building and Housing, unless they want to hear this first. Building and Housing, do you have a preference?
I do not.
Okay, all right, then we'll hear it afterwards. I guess we can move on to Mr. Vanover and see what his take is on this.
So, Mr. Chairman, this is a condemnation of the main structure. This property was transferred to Mr. Gray's in 2016. Although, we're encouraged by the fact that he's now on his way to get the proper permits. He's owned this property for 6 years. You can see, I don't know if the pictures came through or not, but this property, it is a commercial property because it's 4 suites, and it is in a severe form of deterioration. There's, the stairs are missing. It's it's really deteriorated. And the city of Cleveland, the citizens of the city of Cleveland, paid to board this structure up as soon as May 2nd. So there's we have several complaints about it. Of course, the violation notice for the condemnation, and in May we boarded it up. So we would ask that you deny more time and remand it. There's been plenty of time to fix this. This isn't a matter of a tenant being in the property and them not being able to do the work. It was just purchased and then neglected. Of course, they can still get permits and do all the work they need to do. We would just ask that you remand it back to us to monitor.
Okay. Well, let's hear, before we hear back from Mr. Grays, let's hear what the councilman has to say in his letter.
Reading on behalf of Councilman Anthony Harrison for Ward 10. He writes, "Good morning, Ms. Davis. For the record, I am opposed to Mr. Marcus Grays being given more time to evade the violations. This building has sat in despair for years, and Mr. Grays never had any intentions to renovate the building. The building has been flipped back and forth between himself and another person. The property has also been tagged for tax foreclosure." Could you please mute your microphone? The property has also been tagged for tax foreclosure. Mr. Gray should be held accountable for his years of neglect. This will be printed and added to the file.
Okay. Mr. Grays, you're hearing from what the city has to say and also what the councilman had to say. You want to give a comment or?
Yeah, with all due respect to the councilman, I do have plans to renovate the building, and I was not neglecting the building, and I have made efforts over the time to start the repairs. When I purchased the building, it was with great intent to uplift the community. There's a very, very, very difficult hurdle there in that area because of the market value of the property. I wish that the councilman would reach out to talk to me to see if he could possibly assist with the matter. But I do have, again, I do have plans. I'm walking to City Hall now, but I do have plans, and I respect what the councilman said, but I strongly disagree with his interpretation of my intent.
Okay. Mr. Vanover, you have additional comments?
Mr. Chairman, this is Patty. Just very briefly, on behalf of the city, it is not incumbent upon the council person to reach out to the owner. If he believed that he needed assistance, he has every right to reach out to whomever he needed to within the city and any departments, including the council person. So he can disagree with the council person's perception of the situation all he wants, but the council person is speaking on behalf of the community. Thank you.
Okay.
Mr. Chairman?
Yes, who is this?
This is Vanover. So,
oh, yes, go ahead.
So just to respond, we hear a lot in these hearings about the the neighborhood and the property values, but those property values were in place when the property was purchased. You know, not much has changed. And it's deteriorated and abandoned and neglected structures like this that are bringing all the property values down. So it's not actually in this case, it's not actually a symptom of the neighborhood. He is the cause of these problems. And as Ms. Aston said, not only does, this is an investment, this is a commercial enterprise. So it's not only does he have the right to reach out to the councilman and anyone else that he feels he needs help from, he has the responsibility. So I think it's, based on the tax information, the condition of the property, this is a last ditch effort to stall. And we would ask that you deny any more time and remand it back to the Department of Building and Housing.
Right. And I'm inclined to agree with what the councilman was saying, what Mr. Vanover is saying, is that our remanding this, upholding the violations and denying any more time and remanding this property back to the Division of Building and Housing for any further authority on this particular building does not stop you, Mr. Gray, from going forward and just doing everything that you say you're going to do. And so you go ahead, and if you're there, submit everything that you got with your contractor and get rolling on it. And that's the best way to show everybody that you do intend to fix it up and clean it up, and you're all set. So I would recommend that we do just that. Motion is in order to deny any more time and remand the structure back to the Division of Building and Housing.
So moved.
Okay.
Second.
Motion by Mr. Maskey, second by Mr. Dank.
Mr. Maskey,
Yes.
Mr. Bradley,
Yeah.
Mr. Dank,
Yes.
Mr. Gallagher.
Yes. Okay, thank you, Mr. Gray. You will be notified in 2 weeks.
Okay, thank you all for your time.
Okay, next docket. Is A622, 3701 East 116th Street.
Application and fees are in order. Notice of violation is a condemnation of the main structure issued on May 12th of 2021. Appeal statement was received June 9th of 2021, requesting for more time to abate the violation. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston, Law. With the appellant or his and her representative, please state your name for the record.
Annette Gibson.
Okay, I'm just looking for your picture up here. Okay, Gibson, I got you. Okay, solemnly swear to tell the truth, the whole truth, so help you God?
Yes.
Okay, go ahead and let us know what your plans are.
So the plans are to renovate this property into a 4-suiter affordable housing unit. And we're just asking for more time to abate the violations. We did submit blueprints from our architect, and we're just waiting to hear back from that department when we can move forward with the next step with that.
Okay, very good. Let's hear from Mr. Vanover.
So, Mr. Chairman, this is a condemnation of the main structure. There is a permit application that was submitted last week with the architect Daryl Mapson doing the drawings. This property appears this was purchased by, it appears that it was purchased in 2019. The notice of violation was written to S&P Properties. Is that the to the appellant? Is that the owner?
Yes.
So, Mr. Chairman, again, this is it's an investment property purchased 3 years ago. in, by a corporation. And, there's been, there's several complaints. We've boarded this property. It's been vacant, distressed for a long time. And we ask that you deny more time and remand it back to the Department of Building and Housing. And if they can proceed with their permits and the renovation, then they can do so under the Ohio Building Code. But that would give us the authority it would allow us to maintain the authority of the over the property and assure that it actually gets done.
Okay, Ms. Gibson, you have a comment?
I do not have any additional comments.
Okay, then unless there's any objections, the board will do just that. We'll deny any more time and we'll remand it back to the city to go ahead and take care of the property. So if you go ahead and proceed, well, we'll get the motion out of the way first. So we're denying more time and remanding back to the city.
Mr. Chairman, we have
Yes.
Ms. Davis with her hand raised.
Ms. Davis, go ahead.
Mr. Chairman, to Ms. Gibson, what is your relationship to the owner? I don't have a contract or agreement or anything in my file for you to represent the owner this morning. Is it possible that you can
A
give that to
secretary
me?
for the company. I communicated with you a couple of times through email, by request from the property owner. If there's something else that needs to be submitted, I can get it submitted to you.
What's your email address that you sent it from?
Annette Gibson at reliablehearts.org.
Okay, heavy breather. If you could just forward those emails back to me because I can't find them in my file at this time, I greatly appreciate it. Thank you.
Okay. We also spoke on the phone a couple of times too, Ms. Davis.
Yeah, we probably have. I don't deny it. It's me in this office, and I talk to probably over 200 people a day. So my wire's a little crossed this morning.
Okay. Well, we'll just make sure that you do get that, and we'll go ahead with the motion to deny more time and to remand it. Okay, motion.
Second.
Mr. Bradley, second by Mr. Dank.
Mr. Maschke,
Yes.
Mr. Bradley,
Yes.
Mr. Fink,
Yes.
Mr. Gallagher.
Yes. Okay, be notified in 2 weeks. Thank you.
Thank you.
Next docket, A2922, 10502 Shaker Boulevard.
Application and fees are in order. Notice of violation is HVAC, interior and exterior maintenance, issued on February 11th of 2022. Appeal statement received March 10th of 2022, requesting for more time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellant or his or her representative, please state your name for the record.
This is Patty, Mr. Chairman, to Carmella. I do not see a Niall LaForce who filed this on here. I would ask the attorney, Ms. Zibble, who's muted, if she's representing this entity or if she has a different docket.
Hi, yes, good morning. I'm here with Stephen Jenkins for a docket that's later this morning.
So not this one. Okay, thank you.
No,
Thank you for
correct.
clarifying that.
And no
So, Mr. Chairman, I do not see anyone listed on this, and I believe to Ms. Davis, I think I talked to you, I have a note to myself about whether or not this person had the proper authority to proceed when it was filed. There are 2 violation notices, but if Mr. Chairman, if you'd like to swear in Mr. Vanover, I can then inquire Ms. Davis as to service.
Sure. Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay,
So,
go ahead.
thank you, sir. To Ms. Davis, did the notice of today's public hearing get returned to the board's file for any reason?
Mr. Chairman, to Ms. Aston, no.
Thank you. And did you receive any phone calls, voicemails, emails, fax, or anything from this entity or on behalf of this entity for this docket?
Mr. Chairman, to Ms. Aston, no.
Okay, thank you. And Mr. Chairman, we would continue our objection to this appeal being filed by this Niall LaForce without proper demonstration of authorization to proceed on behalf of this entity. Otherwise, from Ms. Davis's statements, it appears this board has proper due process notice for this docket to proceed. I anticipate Mr. Vanover is going to ask at the conclusion to uphold, deny, and remand. Thank you, sir.
Okay, Mr. Vanover.
So, Mr. Chairman, this property is one of, unfortunately, many properties in the Shaker Moreland area that is a rental property that is not maintained. There are tenants in this structure that this is a rental inspection violation notice. They're based on my communications. There's several communications with the neighborhood. I'm surprised and disappointed that they're not actually in the meeting. They're really upset about the condition of this property, as well as it's severely tax delinquent. As an investment property, there's an expectation that it is maintained long before the city gets there. And so we would ask that you deny any more time and remand it back to the Department of Building and Housing for further action.
Sounds good.
And Mr. Chairman, just to make clear the record to Mr. Vanover, this is not like a four or six suite, or this is large. And do you know how many suites or how many units there are approximately?
Um,
The VN lists at least 30 or 39.
Yes.
Wow.
Yeah, I
So it
believe
is
that's
a big structure, Mr. Chairman.
Okay, sounds good. Okay, so motion is in order to deny any more time and to remand it back to the Board of Building and Housing for any further action. Okay, moved by Mr. Bradley,
Second.
second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yeah.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, they will be properly notified within 2 weeks. Okay, next docket. A3022 4420 Bush Avenue.
Application and fees are in order. Notice of violation is fire damage issued on February 11th of 2022. Appeal statement received March 10th of 2022, requesting for more time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellant or his or her representative, please state your name for the record.
Mr. Chairman, this is Patty Tacarella. I don't see anyone in the panel. However, I'm also showing that there was a certificate of disclosure if Mr. Vanover can verify, as well as when I look on my place, Cuyahoga County, it looks like Crystal Lemieux, who's listed, I think, there's a Crystal Woodrum transfer to a Prospera vouchers. I think there's a new owner. But to Ms. Davis, did the notice of today's public hearing get returned for any reason?
Mr. Chairman, to Ms. Ashton, no.
And thank you. And did you receive any communication from this, from Crystal Lemieux or anyone on her behalf?
Mr. Chairman, to Ms. Ashton, I did. I received communication from her as well as her husband. She did tell me that they were in the process of selling the property. I instructed her if she would like to withdraw her appeal, that she would have to submit that to me in writing. I have not received any written or email correspondence from this appellant stating that they would like to withdraw their appeal.
So, Mr. Chairman, thank you, Ms. Davis. When you swear in Mr. Vanover, I anticipate he's going to ask that you uphold, deny, and remand. It looks like it was already transferred from the records. Thank you.
Okay. Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay, go ahead.
Mr. Chairman, yes, so there was a permit pulled by Crystal Woodrum, but it was pulled as a homeowner's permit, and due to the transfer, it will that permit will be closed and valid because she's no longer the owner. So we would ask again that you deny and remand back to us for further action. Hopefully the new owner is a responsible owner and we'll make the repairs accordingly. But we ask that you, simply flipping a property does not get one out of, the responsibilities of taking care of it. And so we would need to be able to act accordingly. So we ask that you deny it and remand it.
Okay. Motion is in order to uphold the violation, to deny any more time, and to remand it back to Division of Building and Housing.
So
Motion.
moved.
Okay, motion by Mr. Denk,
Second.
second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yeah.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. They will be notified in 2 weeks. Okay, next docket. A3122 17506 Nottingham Road.
Application and fees are in order. Notice of violation is interior exterior maintenance issued on February 2nd of 2022. Appeal statement received February 8th of 2022, requesting for more time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law, with the appellant or his or her representative. Please state your name for the record.
This is Patty. I'm getting a workout today. If you could swear in, I don't see anyone listed in the panel by this name who had filed it, Jonathan Johnson. If you could swear in Mr. Vanover.
Okay, Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay.
Thank you, Mr. Chairman. To Ms. Davis, did the notice of today's public hearing get returned to this board's file for any reason?
Mr. Chairman, to Ms. Ashton, no.
Thank you. And Ms. Davis, did you receive any communication about this docket or for this entity, Trainoo, Trainoo LLC, a fax, email, voicemail, etc.?
Mr. Chairman, to Ms. Ashton, no.
Thank you, Mr. Chairman. It appears the board has provided proper due process notice to proceed today's hearing. Thank you.
Okay, Mr. Vanover.
So, Mr. Chairman, it appears that there was a certificate of disclosure filed on this 6/30/22 from Trainoo LLC to a Rahi Chakshi. So it appears that this property is either transferred or in the process of transferring. And judging by their absence today, I would say that's probably what's going on, is that they're just planning on flipping it to a new owner. So we would ask that you deny any more time, remand it back to the Department of Building and Housing.
Okay, motion is in order to uphold the violation, deny any more time, and to remand the property back to Division of Building and Housing.
So moved.
Okay, motion by Mr. Denk, second by Mr. Bradley.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. They will be notified within 2 weeks. Okay, next is, it was A14921, but it has been withdrawn. So we will move on to docket A2822, 3796 West 117th Street.
Application and fees are in order. Notice of violations is rental registration, interior, exterior maintenance, and no permit. Issued on February 17th of 2022. Appeal statement received March 7th of 2022, requesting for more time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellate or his or her attorney or representative, please state your name for the record.
We have two Eric Nugents here, Eric Nugent Sr. and Eric Nugent Jr.
Okay, are you both going to be giving testimony or?
How about just Eric Nugent Sr.?
Okay, sounds good. Okay, solemnly swear to tell the truth, the whole truth, so help you God?
I do.
Okay, I'll go ahead and proceed. Let us know what your plans are.
Oh, okay. So as far as the registration goes, we are registered now. As far as the no permit, there were actually no alterations being performed at the time. I think a tenant threw a TV out the front window and it got boarded up. So I think that was what was being considered an alteration. And regarding interior and exterior renovations, we have a extensive plan to renovate the property, interior and exterior, including all of the violations that were listed, and then some. We'll be doing new kitchens, bathrooms, the exteriors being painted, I think this week. I think they're starting today. We have electricians, plumbers, HVAC, and concrete contractors lined up. And again, the painting contractor will start today. With regards to the time needed, we stopped charging the tenants rent in order to help them find a new place to live. There's no basement to this particular property. It's built on a slab or a crawl space, I should say. And there's a sewer issue that would require the entire first floor to be removed in order to get down to the basement. We haven't found a contractor that's willing to crawl into the crawl space and do the work. So our plan is to remove the floor, replace the sewer completely, which would then lead to a full plumbing retrofit. So we're planning on doing it right. We just need time to do it, and we need the tenants to find a new home. Each tenant have multiple pets, so there's been a challenge in finding a home for them, but we're helping them. We have some social services helping them. I think they have some legal help that they're looking. We're all trying to work together in order to get them a new home so we can renovate their current home.
Okay. Sounds good. Let me go over to Mr. Vanover.
So, Mr. Chairman, this property has a number of violations in both units, including smoke detectors and CO detectors. That are required. So any extension of time, we would ask that those be corrected immediately. My concern is that there's this is a plan with no real timeline, because it's waiting for the tenant with no real date. So we would so that's concerning. And then the inability to find a contractor that's willing to perform the sewer work needed. This didn't happen overnight. The windows are deteriorated and broken. The painted, the siding on the outside is deteriorated. So we would, all of these things can transpire. They should have transpired long before it made it to the Department of Building and Housing. So we would ask that you deny more time on this. There's a lot of this that could have been done, prior to us getting there. And also, it looks like the The owner is Freehold Real Estate Service LLC. Mr. Chairman, is that accurate? Is that the owner name?
That sounds right.
Right.
Yes,
So-
we do hold that property in a LLC.
Okay.
All right, Mr. Chairman, to the appellant, how many other properties do you own? Does Freehold LLC or Freehold Real Estate own?
Two, one in Parma, and one in Cleveland, on Lake Avenue, a condo.
Okay, so Mr. Chairman, I'm going to go out on a limb and assume that the property in Parma and the one on Lake Avenue doesn't look like this. It's unfortunate that it's in this condition, and you know, it's. We would ask that you deny more time and remand it back to the department.
Is there any permits been pulled?
There has not.
Okay.
Go
ahead, Mr. Nugent.
Thank you. We will have, each one of our contractors is registered in Cleveland, and they will pull their contracts prior to starting work, or their permits, I'm sorry.
Right. Okay, so again, this is another one of them situations. It sounds like you're ready to go. So if we deny any more time, because there's some things that you have involved here that you're not even sure of time-wise and what it's going to take to go into the first floor and go down there and do what you got to do. But if you're putting plans forth on on doing that and getting the contractor in there to do that, then again, in our case, it's a matter of looking at time. And so it makes more sense for us to deny any more time and to remand it back to the city to keep an eye on the property, and you move forward the way that you said that you were going to do. There won't be any problems, okay?
Okay.
So that's what you need to do. So I'm going to uphold the violations, deny any more time, and to ask the property to be remanded back to Department of Building and Housing. Motion?
I'm sorry, can I ask a question about that?
You can, yes.
Okay, so when it gets remanded back to the building department, what exactly does that mean? I just move along with the work, correct?
Mr. Vanover explain that to you.
Okay.
So, Mr. Chairman of the appellate, it means that you will be required to, you'll be under the building department's supervision to abate the violations in a timely manner. More specifically, you will need to get the CO detectors and the smoke detectors installed and have it inspected, and stay in contact with the inspector to get those corrected. But failure to do so will allow the city our administrative and legal remedies, which could include depending on the conditions, it could include a vacate order or criminal prosecution or other administrative remedy.
Okay, fair enough. Thank you.
Okay, very good. So motion is in order.
So move.
Okay, motion by Mr. Bradley,
Second.
second by Mr. Denk.
Mr. Maschke,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Okay, you'll be notified in 2 weeks. Thank you.
Thank you.
Okay, next docket. Now we have the next docket, 3222 has been rescheduled. So we will be moving on to A 3422, 9202 Marshall Avenue.
Application and fees are in order. Notice of violation is interior and exterior maintenance issued on January 28th of 2022. Appeal statement received February 11th of 2022, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. With the appellant or his or her attorney or representative, please state your name for the record.
This is Patty. I do not see a Mark Campbell listed on the panel.
So, Mr. Chairman,
Go ahead.
our records indicate
Oh, yeah.
that this was actually in compliance.
Okay.
So
So we give.
swear in Mr. Vanover. Go ahead,
we'll-
swear him in.
Okay.
Take that.
Solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Okay. Go ahead, Mr. Vanover.
So, Mr. Chairman, the inspector indicates that this was compliance final as of 6/28/2022,
Okay.
and the violation notice closed.
Okay. So we give to today's date.
We would not object to that.
Okay. So a motion is in order to abate all violations by July 6, 2022. Motion
So moved.
Second.
moved by Mr. Dank, second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay. Well, they'll be notified in 2 weeks.
Mr. Chairman, give me 1 second.
Sure.
Okay, Mr. Chairman.
Okay. That was pretty quick.
Yeah, that's Mr. Gray's in the office.
Okay. So we called this docket 3522-2112 West 93rd Street.
Application and fees are in order. Notice of violation is interior and exterior maintenance and no permit. Issued on January 13th of 2022. Appeal statement was received January 24th of 2022, requesting for more time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellant or his or her attorney or representative, please state your name for the record.
Hi, yes, good morning. This is Attorney Monica Zibel, and I'm here representing Stephen Jenkins, who I believe is also online this morning.
Okay. So we may be hearing from both y'all. I'll ask you both. I'm going to swear you in. So solemnly swear to tell the truth, the whole truth, so help you God.
I do.
I do.
Okay. Ms. Zibel,
Yes.
are you gonna be speaking on behalf of Mr. Jenkins?
Yes, there may be some information that he can provide that will provide additional information to what I have to offer you today. So me and Mr. Jenkins started talking late at the end of June. I did submit some photographs and receipts, and the HVAC permit that was pulled, I know that it was not timely. I did submit that yesterday. If you would permit me to share my screen, I'm able to show you the photographs of the violations that have been corrected. My conversations with Mr. Jenkins, he has indicated that there are only 2 outstanding violations left to be addressed. Those are number 3, I believe, and number 17. So we do have photographs and receipts and other permits I can share with you if you would allow me to do so.
Okay, Mr. Rulons, are we able to do that?
This is Maurice Rowland, City Planning. No, we have that feature disabled for this meeting. We do not do that.
Right.
Okay, we're not able to do that.
Mr. No, if she can submit those to Carmella, I would, you know, I'm not going to object that she has those if she submitted those for the record, as long as the board receives them. Thank you.
Okay.
Mr. Chairman, to Ms. Ashton, I did receive the email at 11:37 last night.
Right.
I did print them out and they are part of the file.
Perfect. Thank you.
Okay, very good. Okay, so go ahead on with your comments, Ms. Sybil.
Sure, yes. So Mr. Jenkins would just request some more time to complete the remaining 2 violations that he needs to address. Like I said, one of those was securing a permit for the HVAC work, which he has done. The violation was issued to him on January 13th, and he did apply for that permit on January 21st. So he's been aggressive and proactive in doing what he needs to do to get this corrected. Like I said, violation number 17 has to do with the ventilation in the home at this point, which is going to be addressed. And I believe number 3 has to do with some exterior work with the fascia and the gutter boards. So he's just requesting more time to address those remaining 2 violations. And if Mr. Jenkins has anything to add.
Okay. Well, we're kind of looking for how much more time are you requesting?
He indicated to me that around 9 months would probably be sufficient to complete that. I think that the house is in need of extensive HVAC repairs and upgrades. I don't know.
Well, that's a correction. The HVAC just needed a permit.
Oh, okay.
Just needed to be applied for the permit. The permit was submitted and provided. So the only 2 violations that's left is just painting of the fascia and gutter on the outside, and then a vent in one of the bathrooms in the upstairs unit. So just requesting a little bit more time to kind of address those items, because majority of the violations were due to a leaking roof, which I had to actually replace. So a good amount of money have been put into this property right now, and just need some more extensive time to kind of gather necessary funds to just address those remaining 2 violations. Like I said, most of these are just the remaining violations, just cosmetic and just a vent in the upstairs bathroom.
Okay, so Mr. Jenkins, I mean, realistically, how much more time do you need?
Approximately about 9 months, because it's problematic just trying to find a contractor to do the necessary work that is needed at a good quality service. So,
okay,
Mr. Chairman, this is Patty. 9 months seems excessive for him saying it's cosmetic and it's just painting an event.
well, that's the reality of it. Like I said, extensive funding has been put into this property to make sure it's up to code, and it's cosmetic standpoints from just a community standpoint, just being not looking so run down and everything. So I'm just asking for a little bit more time on that, and that's the reality of it.
I'll give you an example. For a house that's in condemnation, and many times it's within 6 months that we're asking them to do a full out of condemnation rehab. So you're kind of have this out here as that it's some cosmetic things and wanting 9 months. That's why the questions are being asked. So let me go over to Mr. Vanover and see what he has to say.
So, Mr. Chairman, according to the appellate's testimony, there are 2 items. It's the fascia and the event. There are no inspections, follow-up inspections. So I would ask that this be inspected to verify that these are actually in compliance within the next 2 weeks. We don't object to more time, but based on information provided, we would object to anything more than 30 days. There's already an HVAC contractor working on the property, so they can, be contracted to install the vent that's required, and then the fascia and the work outside is just a matter of getting it done. I understand that there's been a lot of funds put into the property. But it is a rental property. It's an investment. It's a commercial enterprise, and that's the responsibility of the owner prior to us, the city, coming to the property it's not our responsibility to audit your property and tell you what needs done. These things should have been done and completed long ago. So we don't object to 30 days, with the understanding that it will be in full inspection within 2 weeks, because we'll also need to verify that it has been exterminated, because there is an infestation violation as well as a smoke detector violation. So so yeah, that's it.
Okay. All right.
Can I make a comment? So yes, an invoice was sent over to confirm that there wasn't any rodent infestation at this property. It was sent over right away during my appeal, as well as there's really no contractor needed. Oh, I'm sorry. As far as the ventilation, like I said, it's just trouble trying to find a contractor who actually can commit and do the actual work. So that's why we are waiting for just extended time to try to make sure we vet contractors and make sure we can actually get someone who actually provides some quality of service on this.
But if I may, Mr. Chairman, the appellate, you have a furnace company working currently at the property, correct? Or no, that's a homeowner permit. Understood. So so according to your permit, Destiny Jenkins is installing the furnace.
No, Destiny Jenkins is the owner. So we got a residential permit for this already.
Yes, you have a permit that says Destiny Jenkins is installing the furnace. You have a homeowner's permit that she's doing that. Who is installing the furnace?
The furnace was installed already when we purchased the actual property. We just needed to get a permit. We needed to get an inspector to come out there and permit the actual work on that for that residential property. And that was done.
Well, Mr. Chairman, I'm a little confused because there's an HVAC permit that was pulled as a homeowner's permit for Destiny Jenkins, and yet the claim is that it was installed when you bought it. Yet the violation notice lists issues with the furnace system, the heating and cooling system, including the.
Yeah, based on my conversations with the city when I called about this, they stated, number one, that there should never really been a violation on this actual.
Who stated that, from Mr. Chairman, appellate? Who stated that for the city?
Let me look back at my. Let me see if I can find my notes real quick. Let me see if I can find that real quick. 1 second. Okay, I spoke with a Miss Connie Tatum of City of Cleveland, who handles havocs.
And your testimony is that Mr. Chairman, the appellate, your testimony is that Ms. Tatum told you that a violation notice should have never been issued.
Yes, she said she was going to be in contact with who was the inspector that came out? It was Andrew someone. But yeah, she walked me through of actually just getting the permit submitted during that time. Let's see. Yeah, she said she was going to reach out to Mr. Aaron Arnold from the City of Cleveland. So.
Mr. Chairman,
because the
if I can real quick, to, Mr. Vanover, this is Patty. Even I will presume the appellant's testimony is correct. He takes wrong advice from personnel at his own peril. There's case law to that extent. But if he's, Mr. Chairman, to Mr. Jenkins, did you receive these violation notices?
Yes, I received the violation notice.
So he received the notices, and the inspector, Aaron Arnold, is listed on the bottom of each of those. He most certainly can reach out himself. It includes an email address. I'm looking at it, that he doesn't need other persons to reach out for him. It's incumbent upon him. At the bottom of the violation notice, it says, to contact your inspector, call Monday through Friday, gives the name, the phone number, and email address. So he's most certainly capable of reaching out to Mr. Arnold to himself to inspect and get that stuff, get the information from the inspector himself. So we would state nothing changes based upon any of this testimony. 9 months is excessive, Mr. Chairman. Mr. Vanover testified there's a homeowner's permit. If they're going to have a contractor do anything, they have to a contractor has to separately pull a permit. That's the law and the codes. We would ask that you uphold the violation notices as properly issued. It appears that the proper permit has not been obtained and is required. We would ask that you order a permit, the correct permit to be obtained based upon the appellant's own testimony. That an HVAC permit is required if there is problems with this HVAC system, and it appears to be currently occupied, which has tenants that need to be in a safe place. And we would I would defer to you and based upon Mr. Vanover's testimony as the sufficient amount of time. We would adamantly object to 9 months, Mr. Chairman.
Yes, I agree.
So for record, I'm confused. I'm confused about this because number one, the Havoc system works. The cooling and the heating works. Like I'm trying to figure out exactly what is actually needed here, and that's why there was so confusion here.
We need to get the inspector out there to verify all these things, and that's why we're going to require you to within 2 weeks to have an inspector come out and to verify what's working, what permits you need, and so that everybody knows. And then I'll give you additional time to till July 1st, 2022 to get it re-inspected, and to August 5th, which is 90 days, 2022 to correct any more of the violations that exist.
Mr. Chairman, you just said July 1st, but today's the 6th.
Say that again.
What day did you say?
I said October 5th was so it'd be October 6th. 90 days to 2022 to abate all the violations.
And the inspection by what day?
July 20th. That's 2 weeks. Okay, 2022 on all dates.
And I would like to add for the record too on this that the units for this particular property are not currently occupied by any residents.
Ms. Sybil?
Yes.
Go ahead.
Thank you.
Yes, I just wanted to add, as Ms. Aston said, that there may be tenants in there. It's currently unoccupied, so there are no residents or any tenants currently in those units.
Okay, then it makes sense that he gets the work done to get tenants in there.
Right.
Okay. All right. So the motion is in order to for the requirements July 20th, 2 weeks to have its property inspected by inspector, and October 6th, 90 days, 2022 to complete all the violations. Motion in order.
Second.
Okay, motion by Mr. Bradley, second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, you'll be notified in 2 weeks. Thank you.
Thank you.
Okay, next docket. A 3622.
Application and fees are in order. Notice of violation is interior and exterior maintenance issued on November 29th of 2021. Appeal statement received December 10th of 2021 requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston, Law. With the appellant or his or her attorney or representative, please state your name for the record.
Mr. Chairman, this is Patty. Maurice, if you could move the screen to A36, and I do see a Francis Caldwell on, but is muted, who appears to have filed this docket.
Hello.
Yes.
Hi.
Okay, so we do have you on here, Francis Caldwell, and this is for 1824 East 90th Street.
That's it.
Okay. Okay.
I'm on as well.
And my attorney
down.
Mr. Dow.
There's a Mr. Dow on? Yes.
Yes,
Okay.
is there
And
attorney?
you will be, yeah, are you the attorney? Or just speaking? Okay. Okay. I solemnly swear to tell the truth, the whole truth, so help you God.
I affirm.
Okay. Whoever's going to be speaking, tell us what the plans are.
I'll let my client, Ms. Caldwell, speak on the
Okay.
particulars.
Okay, this house, I was evicting the tenant that lived upstairs and she got upset, so she called the city, which, you know, she's still there. We kind of worked out our disagreement, so she still lives there. But I've had the house for a while. It belonged to my mother, and she left it to my sister, and my sister kept it for a while, then she sold it to me. So it needs a lot of work. Mainly, it needs vinyl siding. It needs all new windows. And by the rent being, you know, really low, because she only pays, I think, like $500 a month, and I have to pay water, sewer, taxes. So I really don't have enough money, to be honest, to put into the house. But I am working with the city trying to get some type of a grant or a loan where, because when my mother owned the house, they gave her a new roof and painted the house for her and, you know, cut down trees in the backyard when she owned it. But since she passed away, we haven't done, my sister didn't do anything to it. Well, she did do work on the inside, take that back. She did do a lot of work on the inside and made it a little more modern than what it was when my mom was living there. So basically, I just need time to try to find a grant or a loan or something, because right next door to me, they're building some brand new apartment buildings on 90th, and then across the street also. So I really, you know, even before this happened, I still had plans on upgrading it because the people right next door, you know, they're building like a brand new 4-story, you know, high-end apartment complex. So I do want to, you know, make my property kind of comparable to theirs. So that's my issue, is funding.
Okay, Ms. Caldwell, do you live there?
No.
Okay,
No.
so you just have one tenant?
No, my grandson lives on the first floor.
Okay.
Ahmad. He just moved in January, but, you know, he doesn't have a job, so he's not, you know, paying any rent right now. He just got his CDL license, so he's trying to find a job. He just turned 21 to be a truck driver, so that's my issue.
All righty. Well, let's hear from Mr. Vanover.
Mr. Chairman, to my knowledge, there are no programs that the city has to invest in investment property of this kind. Owner occupants, there are grants and there are programs for that, but being that this is an investment property, we would ask that you deny any more time and remand it back to the department. To the appellant's testimony, there is no funding and no real plan. Again, this is, I understand the plight of, you know, trying to keep the family home. But with the expectation is that it's maintained, and the neighborhood if there is, you know, there is new housing, there's new development going on around. There's an expectation that you know, there's quality housing in the city. So with no real plan, we would ask that you deny any more time, you remand it back to the Department of Building and Housing.
Okay. Ms. Caldwell, you have any other comment? That doesn't mean that you can't do something with it, but
I mean, the main thing I know is siding. It needs siding, because painting, that That's just too much to paint it. It's just a lot. So really needs siding and all new windows. I did order some windows because on my violation list, he did list windows. So I did buy 5 new windows. They haven't been installed yet, but I have them there in the hallway, the back hallway of the house. So I am going to have those installed. So I did purchase those, and they were like $175 per window. So, I mean, I'm just being real. That's kind of my dilemma right now. So when you say remand to the city, what does that mean exactly? I mean, I heard another man, you kind of mentioned it to him. But if you don't, so you're saying if a person doesn't have the funding to put the house back together the way the city wants you to put it back together, then is Mr. Vanover suggesting then you're forced to sell your property because you can't afford to keep it up? Is that
Mr. Chairman, this is Patty. No, the city is not saying that. The city would never say that. The property always remains with the property owner. The city has laws that it has to enforce, so the city would determine upon remand what is the most appropriate enforcement mechanism. That is what remand means. It means you're no longer under the purview of the board and the time governing by the board. But it does not mean that the city is forcing people to sell their property.
Right. If you're able to get funding from somewhere or do something, or then you can, you do what you got to do to abate the violations. But anyways, it puts it underneath the city's to keep an eye on it and do whatever they have to do in order to get the property back to where it should be. Okay. So that's what it, and in cases where people do not have the funds, it's really the only thing that we can do. I mean, this is not unusual. Sometimes we have to do this, and you've heard other cases where we've had so that's again what I believe we should do is that we'll uphold the violations and deny any more time, and to remand it back to the city for any further.
So that just means as you get stuff done, you have to call the inspector and tell them?
Yeah, you can still work with the city if you can get things done. The city the city would love it if you could get it done. There's no doubt about it. And you just keep working at it, and things can happen. But it's like Mr. Vanover said, that unless you were of a certain age and that, the city just does not have any programs for someone that just needs to get something done. You're a property owner now, and so, you got to do what you got to do, but, it'll be under them to keep an eye on it.
Well, let me ask Mr. Vanover a question.
Sure.
So in my case with so would they accept, so the house is peeling, right? It's certain areas where it's peeling. And I know years ago, my husband used to work with the FHA, and they would let people like scrape off the peeling part, and then they would repaint it with a color that's close to the color that it is. Can you do that until you get money to do the siding job?
So, Mr. Chairman, to the appellate, the violation notice, identifies the peeling paint. There's several methods. I am reluctant to opine on how that should be treated because, I'm not the consultant for investment property owners. There are a lot of methods. I would recommend that you consult a professional on how to do that, because I don't have the authority to provide that information. And as I said, that as long as you're working with the inspector and progress is being made, we will continue to inspect. That's what we do. But as the chairman said, there are no programs for investment property. We have thousands and thousands of investors who speculate and buy property and hold on to them and don't maintain them because either they just choose not to or they can't afford to. And our responsibility is to get the property maintained to the standards of the ordinance. And as an owner, that is the owner's responsibility as well. And the reality is either it's got to get repaired by somebody.
Okay. Okay.
Mr. Chairman, to the appellate, there's always a second mortgage that you can get funds from a bank.
Get funds from the bank. Is that Mr. Bradley?
Yeah. Mm-hmm.
Okay.
Okay, Mr. Bradley, thank you for that. I'll look into it.
Okay, so the motion is in order to uphold the violations, to deny any more time, and to remand it back to the city for building and housing. Motion?
So move.
Mr. Bradley?
Second.
Second by Mr. Dank.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, you'll be notified in 2 weeks. Thank you.
All right, thank you. Bye.
Okay. Okay, so we have next docket is A3322 permit extension, 3278 West 34th Street.
Application and fees are in order. This is an appeal to keep the following permits open from suspended or abandoned work. You have permit B190-36919, P190-36926, and H190-36927, and E190-36925. They are issued on February, the notice was issued on February 28th of 2022. The appeal was received March 4th of 2022. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellate or his or her attorney or representative, please state your name for the record.
This is Patty. I do not see a Renarda Fox listed, and there is an email address on here. There is a Pamela Stevenson, but I don't know who Ms. Stevenson is here for, but I do not have a Renarda Fox. So if you swear in Mr. Vanover, I will inquire with Ms. Davis.
Okay, Mr. Vanover solemnly swear to tell the truth, the whole truth, so help you God.
I do.
Thank you. Mr. Chairman, to Ms. Davis, did you receive did the notice of today's public hearing get returned to this board's file for any reason?
Mr. Chairman, to Ms. Ashton, no.
Thank you. And did you receive any further communication on behalf of this docket, voicemail, email, fax, etc.?
To Mr. Chairman, to Ms. Ashton, no.
Thank you. So, Mr. Chairman, it appears you have proper due process notice to hear this matter. Thank you.
Okay, Mr. Vanover.
So, Mr. Chairman, the structure was condemned by the city in 2018. And subsequently in 2018, a permit was pulled to correct the condemnation. No work was done on that in 2018. It was subsequently closed for abandoned work. During that time, at this time, it was owned by a Felicia Fox that pulled those permits. The city subsequently boarded this structure twice. New permits were pulled in 2019, and these are the permits that are before us today. And again, no work has been done, and they were subsequently closed. We ask that you deny the request to reopen these permits. This is the second time we've allowed them, and they've gone through the permitting process with no work being done. It is the city's position that this is just a tactic to stall the demolition or prosecution of the property. And so we ask that you deny any more time. They do not reopen the permits and uphold the violation, uphold the order to close them as invalid.
Okay. Motion is in order to deny reopening these permits that are abandoned and to remand the property back, or to just not allow them to be opened. So,
Mr. Chairman, this is Patty. You can deny and remand. It would go back to Mr.
All right, we'll
Appeal.
do that
Thank
then.
you.
We'll just deny and remand and no more time on the permits. Okay.
Move.
Mr. Bradley, motion.
Second.
Okay, second by Mr. Ding.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, they'll be notified in 2 weeks. Next docket, 83722, another permit extension, 6811 Fullerton Avenue.
Application and fees are in order. This is an appeal to request to maintain the opening of the permits from suspended or abandoned work. The permits are as follow: B200, B2001160, H2001120, and E2001119. These were, the notice was issued on January 31st of 2022. The appeal was received on February 23rd of 2022. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law. Would the appellant or his or her representative or attorney please state your name for the record?
This is Patty, and unfortunately, I'm very well aware of this Fullerton property. Prior litigation. Mr. Chairman, I do not see Richard Stettin, Stettin, who has provided an email address on here. And I will elicit testimony from Mr. Vanover to show that the property has been transferred according to the public records. If you go to My Place, Mr. Vanover, and look that up. If I can inquire as to if you could swear on Mr. Vanover and then inquire as I'll inquire as to service. I'm going to be a little thorougher on this one. He had a lawyer and sued us previously. That's why I'm doing this.
Okay.
Okay.
So I'll swear in Mr. Vanover.
Yes, please.
Solemnly swear to tell the whole truth, so help you God.
I do.
Thank you, Mr. Chairman. To Ms. Davis, did the notice of today's public hearing get returned to this board's file for any reason?
Mr. Chairman, to Ms. Ashton, no.
Thank you. And Mr. Chairman, to Ms. Davis, did you receive any further communication on behalf of this docket from anyone? Fax, email, voicemail, etc.
To Mr. Chairman, to Ms. Ashton, no.
Thank you. Mr. Chairman, to Mr. Vanover, do you show that this property has been transferred?
Yes, Mr. Chair. This property has been transferred from a Richard Stettin to Rahina Savchuk, and that's who yes. And so Mr. Stettin was the current previous permit holder.
And Mr. Chairman, to Mr. Vanover, do you show any certificate of disclosure having been filed on this matter?
I do not. This was a quit claim deed, and therefore, but it does have a sale amount of, pardon me, it does have a sale amount of $10,300.
And is a certificate of disclosure required for this?
For the sale of any property, it is required. I mean, it is required for this one as well.
Thank you. So, Mr. Chairman, Mr. Chairman and Mr. Vanover, are these the first permits to rehab pulled on this property?
Mr. Chairman, Ms. Aston, no. This is actually would be the second set of permits on this, and since Mr. Stettin's permits were closed, there's been another set of permits pulled from Rahina Savchuk.
So the current owner, new owner has their own permits?
That is correct.
So, Mr. Chairman, we're going to ask that you, based upon that testimony, I don't think I need anything further, you could deny and remand this to the city of Cleveland because Mr. Stetton got rid of the property and the new owner has pulled permits. Is that accurate, Mr. Vanover?
Yes, it is.
Thank you.
That's what we'll do.
Thank you.
Motion is in order to deny reopening of these permits and to remand it back to the city.
Thank you.
So moved by Mr. Bradley.
Second.
Second.
All right, second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, they'll be notified in 2 weeks. Approval of resolutions. Docket A 13421, A 13721, 15021, 1722, 1822, 1922, 2022, A 2322, A 2422, 2522, 2622, 2722, A 8422, A 8822. Motion?
So move.
Second.
Okay, motion by Mr. Bradley, second by Mr. Maskey.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Approval of the minutes for June 22nd, 2022. Are there any additions or corrections?
No.
Motion to approve.
So moved.
Second.
Moved by Mr. Dank, second by Mr. Bradley.
Mr. Bradley,
Yes.
Mr. Maskey,
Yes.
Mr. Dink,
Yes.
Mr. Gallagher.
Yes. Okay, is there any further business to come before us?
No.
Nothing. Okay, we are now adjourned. Thank you.
Have a good couple of weeks.
Couple weeks.
Take
Okay.
care.
Thank you.
Bye, guys.
Bye for now.